Okay, ladies and gentlemen, ladies and gents, there's going to be a video coming up right after my speaking here. I'm going to splice this one together with that one so that you guys will know. I was doing a video on my way up the road, up the hill, coming back to my home. It is basically an hour and 15-minute ride from here to the city. So pay attention. 45 minutes, there's no signal. 45 minutes, no signal, intermittent. But I was using a Bluetooth speaker to do the recording with the windows rolled up and ground noise. You can at points not make out what I'm saying. However, the most important points. Turn up your radio, your earphones, your headset, and you'll be able to hear the words clearly. Okay? I'm going to play it. Get out of here. I'm going to play it, because the information is too important. And I don't have the time to do it over again because that's 40 some minutes worth of talking. So, without any further ado, or don't, bye-bye. Be right back. Okay, ladies and gentlemen and ladies and gents, I got some driving to do. I have a Bluetooth being held in my hand so that I can speak to y'all. It'll work on this Bluetooth, but it won't work on my Bluetooth headset. We got some talking to do. So we're going to make this a twofold video. One, we're going to talk to our SAT packers and all of our defrauded homeowners of America, and pay attention, our saved program individuals in one video. The first thing we need to let you know, we're going to put this information out for everybody, but this information is primarily for individuals who are going through either foreclosure or debt collections for default on loans or debt collections for defaults on automobiles. All of you. We're going to get you a best friend. So some of you are more familiar with this than anybody else. So this is already stuff people have been doing, but they are not doing it the way we are. Dealing with mortgages and auto loans and student loans. Anybody claiming you owe a debt, get your Truth in Lending Act statement. Now pay attention. It may not be titled that. So if you don't actually have the Truth in Lending Act statement, and all of our people have been asked to get that from their banks, and most of them have already gotten that, so you're already ahead of the game. Truth in Lending Act statements are only for consumer credit transactions and for nothing else. Truth in Lending Act statement is only for consumer credit transactions and nothing else. Consumer credit transactions fall under the Uniform Commercial Code. We are only concerned, for the most part, with the Uniform Commercial Code, Article 9, Section 210. Article 9, Section 210 speaks as to authenticated records of accounting, meaning that they must provide an authenticated record, certified record of the accounting. The courts have been saying, well, they don't really have to provide that. That only applies to credit transactions and not to mortgages. Ladies and gentlemen, everybody is getting twisted by that word mortgage. Talking about you got a mortgage on your home. I don't have a mortgage on my home. Ladies and gentlemen, you don't have a mortgage on your home. That's just what they called it. It's not a mortgage. You received a consumer credit transaction, which is under the Federal Reserve Act. And this consumer credit transaction was directly associated with Section 16 of the Federal Reserve Act, paragraphs 2 and 4. The bank gave you a provisional credit, and they were supposed to receive their funds from the Federal Reserve. That's your other thing that you're going to bring up. Section 16, paragraphs 1 and 2 of the Federal Reserve Act. This is a consumer credit transaction. The bank did not loan you a single dime. They loaned you credit. It's right there in the Truth in Lending Act. Go ahead and take a look at it. For the credit. It keeps saying for the credit, for the credit, for the credit, not for the money. So, what you're going to do is you're going to go to small claims court. That's right, small claims court is quicker. Less than 3 months. Small claims court. Doesn't matter if you're in foreclosure or whatever. Small claims court. You're still going to sue them in small claims court. And when you sue them in small claims court, you're bringing up one thing and one thing only. They failed to provide the accounting that's required of them by law. Now, all of our people, we asked for the authenticated record of accounting specifically, and they ignored us. Now, our people brought this up in court, and they ignored us too. So we're going to go through small claims court, and we're just going to sue them for violations of the Truth in Lending Act. Now, they're going to say, well, that's federal. No, sorry, you are mistaken. This was done on the state level, and because of the agreement between the federal government and the state, I can bring my claim of them violating this act because they violated this act in its private contract. Federal government has no jurisdiction over private contracts. This act only says how they can be penalized. People use small claim court for the Truth in Lending Act all the time. You're going to do the same, but you're going to get them for the authenticated record of accounting. Now, some of you guys are already realizing how genius this is. Now, I'll tell you why it's genius. Because somebody called me up today and said the court denied the stay for the bankruptcy. Courts deny stays on bankruptcy um, for one reason only, so that the banks can foreclose on your home. There's no other reason why they would deny a stay. If they're thinking that you're wasting the court's time, then just dismiss the bankruptcy. If the bankruptcy is wrong, then dismiss it, you ignorant idiot. But they deny the stay so that you can be kicked out of your home, so that you can be more stressed. So don't stress. Let's stress them. File a small claims lawsuit against the bank for the maximum amount on the issues that they violated your consumer rights, not the Consumer Credit Transaction. I mean, the Truth in Lending Act, but that they violated your consumer rights. You want to be a consumer. All of your protections are in your ability of being a consumer. Don't go looking at them videos trying to tell you what a consumer is. Go find out what a consumer is. Go find out what a consumer's rights are. And then go look at those videos. See, most of those videos talking about consumer rights, most of the laws that they're quoting, they're reading them wrong. They're not applying the rules of statutory interpretation. Ladies and gentlemen, I was just telling a group of people today that when I was 16, I was sitting in board meetings with the Army Corps of Engineers, creating policies for that organization, that building. Now, hold on now. This is a federal building. I'm 16 years old, and they're asking me for my input. The reason why is because they saw how I talked and the words I used and my understanding of the law. I didn't get an understanding of the law from Maxine Waters. Maxine Waters only helped me with my understanding of law. I got my understanding of law from Jehovah's Witnesses, from the Bible, because they teach people about the Bible. They teach us about Leviticus and Leviticus, Book of Law, Deuteronomy, Second Law. They taught us about those 613 laws and how they did apply. But when Jesus came, the law was done away with at his death. Sorry, that was the whole purpose of the law. It was a tutor leading to the Christ. Anyway, that's what they've done, is help me to understand law. Then all you have to understand is man tries to copy God. They try to copy perfection. So they try to create laws themselves that equate to perfection. And they don't even come close. So that's how I've come to understand the law. But today, when the person told me that the bankruptcy court denied his stay, I told him, give me a couple of hours while I think about this. And so I went to my God, and I said, my God! And anyway, went to my God, and I said, I need your help. And a couple of seconds later, hey, small claims court. And then after I thought about it, and then going after him for violation of the Consumer Protection Act, that's right, you heard what I said, Consumer Protection Act. That's how you're going to get them. Every state has its own Consumer Protection Act, and you get them under your state's version of UCC Article 9, Section 210. So go to Google UCC 9-210 hyphen, put a dash, not a dash, well, you can put a comma, your state name, and it'll pull up the actual code that applies to your state. And you want to use both the national and the adoptive state UCC 9-210. The courts have to follow that. They've adopted it. They said they're going to follow it, and the courts recognize that. This is called a suit in equity. Are you saying that they get to do equity? Well, you don't have to go and learn equity. Equity is just right and wrong. There's a right and a wrong way to love somebody. Okay, equity is just right and wrong. The court can't do wrong to make somebody else right. Just can't do that. The court cannot operate a wrong. They cannot. They cannot condone it. They cannot support it. They cannot advocate it. So you're just going to highlight the violations. Oh, and some of you are going to want to bring up all that junk. You're going to want to bring up washing machines and bathtubs and silverware and gaskets and faucets and washers and dryers. And why? When it's a Consumer Protection Act issue, you're not going to talk about I don't owe them a dime. You're going to talk about their records are accurate. By law, they can't foreclose on this property. They have insurance. But before that, they violated my rights because we have an agreement that before they even sought foreclosure, they must apply for the insurance. All of you who have a deed of trust, look at sections 5 and 10 of your deed of trust, and it talks about the default insurance. If there's a default, they collect the insurance. That's what they're supposed to do. Then the insurance company is the one that you have to deal with, not the trustee. The insurance company is not represented by the trustee. Pay attention. The insurance company is whom you're supposed to deal with. You're not supposed to be dealing with the trustee. They don't have the right to collect on behalf of the trustee. How do we know this? Because it would be a conflict of interest if they represented the insurance company and they represented the bank at the exact same time. Conflict of interest. That's all you got to say. All right. So, ladies and gentlemen, the reason why you do small claims because it stops all the junk that they're doing. Because now they have to prove there's an outstanding debt. If they send the sheriff to your house, just let them know there's a related case. The sheriff say, "Get out! We don't care." Then you leave. But still follow through on the small claims case. Why? Because you go back into the other court where you got a default judgment, where they said you got to go, unlawful detainer, and you just bring up the fact, sorry, that accounting that they put on the record was wrong. And here's a ruling showing that it was wrong. And those of you who live in states that have juries for small claims, oh, y'all have the best because the jury, not the judge, decides. Okay? So you don't have to be a lawyer. That's why small claims court is so perfect. They ain't no lawyers. In most states, a lawyer can't even come in the small claims court. They have to send a representative. Oops, my bad. That's why this is so perfect. See, the God that I serve, that's how he works. Giving me stuff to combat their stuff. I told you, he allows me to be the presumption killer. They keep coming up with presumptions and we gonna keep killing it. Oh man, you're killing it. Okay, we are gonna keep killing it. I'm gonna have to pull over for a second because this thing has a habit of, I don't know, from time to time it'll stop the video without telling me. And I ain't got time to time, for it to turn off the time and stop the video. I ain't got time for that. So like I said, I gotta make sure. Now this screen, I even have to touch the screen because the screen's got a 30-minute limit before it resets itself. And I think that's the problem, is at that 30-minute limit, it resets itself. Now, let's deal with those of you who are part of the Securing One's Property program with the auto. There's just one final document that you need. Now, people are saying they're handing documents to police officers, and the police officers are throwing it back in their face. So, ladies and gentlemen, when you hand a document to a police officer that has not, don't put no case law in front of that idiot's face. Put the actual law. Okay, we've already been giving it to you all week. The first law you put in their face is the Title 18, Section 31, subsection 6 and 10, where it defines what a motor vehicle is. And it is a person who is engaged in the use of that vehicle for commercial purposes. The reason why that's important, because that makes it unlawful for that officer to enforce that if you are not traveling for commercial purposes. If he wants to give you anything that is associated with a motor vehicle, such as operating a motor vehicle without insurance, operating a motor vehicle without a license, operating a motor vehicle without registration, then you just simply have to let him know, sorry, that law does not apply. No, you need to show me what law you're enforcing. They say, well, that's a federal statute. This is a state, blah, blah. No, sorry. You misunderstood. The Supreme Court has stated that the Highway Act of 1956, it's called the Highway Safety Act for short. The Highway Safety Act of 1956 does not do anything but apply on the state level. It is the one that authorized the Department of Motor Vehicles to issue driver's licenses and registrations in the first place. That's all you guys gotta. And the other case is Reno versus Condon, Condon. Did several videos on this already, where the Supreme Court said that was done under Congress's commercial authorization. It was enacted under Congress's commercial authority, Commerce Clause. Well, fine. It could be enacted under the Commerce Clause. That's legal. The Supreme Court said it was legal. It is legal for Congress to enact something under the Commerce Clause, but the Congress does not have the authority of applying the Commerce Clause to you. It really is just that simple. That's what they said in the Condon, Reno versus Condon. They cannot apply the Commerce Clause to the private civilian. Why not? Because the courts nor the states have any authority under the Constitution to regulate the people. The regulations don't apply to you. Don't tell them that. Show it to them. Ladies and gentlemen, if you show a peace officer the law and he ignores the law, then you demand a sergeant immediately. You don't get to sit up here and tell me you're following the law. You are not the authority of the law. And you're going to tell me that you're not a lawyer? Well, then that means that you don't have the ability of moving one step forward. This is not an ability of me arguing with you. This is an ability of you arguing with the law. I'm showing you what the law says. You are telling me what the law says. The two don't mix. You are incorrect in your understanding of the law. Whereas I show you the law and I show you what the courts have said. So that means that I am not misunderstanding the law. That's how y'all need to understand. There's no argument. Don't argue with them. I don't want to hear it. No. Excuse me. You are going to hear it. I just had a conversation the other day. There was a guy, he worked at a county office here in California, and I called up, and he answered the phone, and I told him what I needed, but I said the name, I reversed the way the name is, and he corrected me, and I told him straight up, I said, you know exactly what I meant. Don't correct me again. And he, oh, wait, hold on a minute. This conversation ain't gonna go like that. And I said, oh, yes, it is gonna go like that. I didn't give you permission to correct me. You don't have my permission trying to correct me. Give me a second. I gotta let the vehicle by. Okay, vehicle going. All right. Um, After I told him that, he hung up on me. So I called back and I said, I need to speak with your supervisor. Well, why do you need to speak with my supervisor? Oh, I'm going to be speaking with them about you. Well, why do you need to speak with them about me? I need to speak with your supervisor and I'll let them explain it to you. Well, and he hung up on me again. So I called back. I said, no, you don't understand. I guarantee you, I will speak to a supervisor today. And he eventually put me on hold for 20 minutes. Supervisor comes on. Now, the hold for 20 minutes was necessary. The supervisor was busy. And I even told her, I said, I know you're busy. You're a supervisor. And after that, she and I had a chit chat. And I told her about the individual and him hanging up on me. And I told her about how I know for a fact that he's younger than me. And I gave her the date of my birth, the 5th. And she says, oh, really? Oh, yeah, I'm on the 18th. And we started, having a camaraderie type thing. Then she gave me her word that she would definitely make it a point to get his attention. That's all I wanted. And I told her that's all I wanted. Sorry, that little chime right there, that's cell phone signal. For 45 minutes, there's intermittent signal, so you really can't travel and drive and be on the telephone going this way. It just doesn't work that way. So, like I said, in a moment, I'm going to pull over to the side in this little makeshift parking uh, reserve area where people can pull over to the side and let cars pass. I'm going to pull over to the side so I can check the phone. So, y'all just hold on a second before we continue this conversation. Got to put the microphone down. Yeah, that's the middle console because I just got finished getting some things. So, let's see. All right, 20 minutes, and I moved it around, so we should be okay. And sorry, I got to see all of the emails that are pretendingly waiting for me, but I go through most of that. All right, let's get back to the chit chat. So, ladies and gentlemen, there is a document that we are putting together. It is something that I'm putting together. It wasn't created before. We're adding it to the program. We've given everybody everything that we can give them. So I'm about to tell you guys how to handle police officers and judges. Okay, so I think you do need to pay attention to this. The problem with police officers and judges is that they think they're all powerful. Both departments, because they protect each other. And because they protect each other, we have to take away that protection. Now, how do you take away the protection of police officers and judges? There is something known as the county recorder, county manager, and pay attention, the county risk management department. We're only concerned about the latter two. The county manager is where you go to find out where the judge's bonds are held and what the judge's bond numbers are and where the police bonds are held and where the police bond numbers are. County recorders for the county level. Ladies and gentlemen, after you do that on the county level, for the federal level, then it is the Attorney General's office after you subpoena, not subpoena, but FOIA request that information because it's a quote unquote civilian right. Civilian right? Civilian right. You trying to say civilian right, okay? These are my civilian rights because you're either in the military, on the police force, or you're a civilian. You want to be a civilian. You don't want to be a citizen. You want to be a civilian. That's why the Constitution was very careful when it came to the word citizen. It mentioned the people. They used the word the people for a reason. So I'm more interested in the rights of the civilian who are the people than I am for the rights of citizens. Okay, sorry about that. I almost got to turn off course. Now, back to the conversation. As I said, you have a right to challenge the police officer's jurisdiction. The moment he ignores the laws you're giving him, that's when you tell him, oh no, when I gave you that document, we have a document that we give to our people. It's called, I remind you that you're under oath. That was me challenging your jurisdiction if you were operating outside your oath of office. It appears you're operating outside your oath of office, which is to honor and uphold the Constitution. The Constitution is there to protect my rights. It secures my rights. You are violating my right now. I have a right to know what law you're relying upon. You don't get to make up the law. You get to state what law from the very beginning. Now, ladies and gentlemen, codes, ordinances, revised statutes, those are not laws. Go back and listen. Congress was only authorized to make law. Congress was not authorized to make codes, not authorized to make regulations. They can regulate commerce, but they cannot regulate you. You must understand these are not technicalities. These are the facts. This is what the law says. I didn't make this up. First Amendment says Congress shall make no law. So the legislature has what's known as the legislative process. The legislative process does not permit Congress to make a regulation to regulate the people. Pay attention. Does not permit Congress to write an ordinance to ordinance the people. Okay? Congress can only write assembly bills and Senate bills. And when they pass, they become law. On the federal level, acts of Congress in turn statutes at large. On the state level, law, not codes, not revised statutes. When you understand that the revised statutes and the codes are written, and I will tell you this, written by the Law Revision Council, it's some type of a revision council on the state level and on the federal level that puts that junk together. Put that junk together! Now say! All right, sorry about that. Ladies and gentlemen, now that you know this, once you challenge the officer's jurisdiction, you can cooperate fully. Whatever he orders, just say, excuse me, that sounds like an unlawful order. And you just go ahead and comply. You've already challenged his jurisdiction. And that's all you have to bring up in court. Make sure he's recording. Now, see, if they really want to play with me, I'll let them know that no, you don't have my right to record me, audio or otherwise. There is no law saying that you have to record me, and there's no law saying that I'm subject to recording. You want to take away that right to privacy, then you're going to have to get a court order. And that court order is going to have to be after a hearing. Because your right to privacy is your right to your protected speech. That's why they don't have a right to record you without your permission. Pay attention. Well, they have a right to film you. People can film all day long. You guys, I just did a video pointing that out to you. Every state has a law that prohibits anyone from recording your audio. Anyone. Now, they tried to give the news media the ability of recording and filming, but the news media doesn't have the right to record your voice. Y'all need to really understand that. That's where, remember, the law will conflict at that point. But it doesn't matter how the law conflicts. They don't have the right to record your voice. That's your copyright. That is your voice. It is unique to you. Nobody else has the same voice as you. Somebody can sound like you, they can act like you, but they ain't you. They cannot perfectly mimic your voice. That's how people can tell that something was synthesized because they can never get it perfect. They can only get it close. Well, cigars don't like it. Cigars don't like being close. They need to be separated. Okay, so there you have it. Now, we have to deal with one more thing. I forgot what that was. I said three things and I did mention two. And the last part, I got distracted, y'all. I'm watching the road and everything. And the road, that's what's killing me right now. So I'm going to have to pull over one more time, one more again, before, like I said, this is a 45-minute trip. And I called you guys when I was about maybe 10 minutes into the trip. I called you guys. I'm using my cell phone to record this, so my cell tablet. So give me 1 second, y'all. And we are going to pause y'all. Okay, I remembered what it was. There was three things, and I didn't forget. I did the police and I did the judges. Ladies and gentlemen, going to risk management on the county level and getting the judges' bond information. Going to the county manager and finding out where that bond information is located. You don't have to beg the police officers anymore. You do a FOIA request or a public informations request. FOIA is federal, so public information is what most states classify it as. So you do a public informations request. And once you do your public informations request and you follow the basic procedures for public informations requests, if they deny you, now it's suable. Small claims court again. That's right. Now you get to take them to small claims court for not revealing that information. Why do they need a bond? Well, ladies and gentlemen, everybody needs to have insurance. You guys know that when you're driving on the highway, they tell you need to have insurance. The insurance is just in case you injure someone. Now, that insurance is unlawful, it's illegal. They cannot make you have insurance for the possibility that you might injure someone. No, that's against the law, ladies and gentlemen. The law says that you have the right to a hearing prior to having any significant due process right taken. Well, claiming that you're a danger to society without a hearing, without a trial, is a violation of the Fifth Amendment. So they cannot require you to have insurance. They cannot require you to have a license. They cannot require you to have registration. Why? Because those things are all for documentation purposes. That's to take away privacy. Now, I'm not asking y'all to go into court on this. I'm just telling y'all what the law says. And let somebody come up and say, well, no, the Supreme Court what? F the Supreme Court. What did the Supreme Court do? Supreme Court doesn't write law. There is no law giving the Supreme Court the authority to write law. Supreme Court doesn't get to make law. They don't get to say, oh, well, no, it's okay for them to do that and it's okay. No. Supreme Court has to follow the law. And there is no law giving no government agency, no government branch, no government anything the right to, one, spy on you. I put a spy on you. Sorry, about to drop my speaker because I'm trying to pick up the phone on this highway doing 180 miles an hour. I'm not doing 180, I'm only doing 50. But everybody else does 65. I'm not in a rush. I'm looking at the cloudy skies. The clouds are not in the sky. They're way over on the mountains. The sky is actually kind of nice and blue. That's amazing for California. All right, getting back to the conversation, ladies and gentlemen. Now we have this whole thing about banks and their insurance. Now the banks have to be insured as well. Find out who the bank's insurance company is and file a claim against the bank for violating your secured rights, violating the terms of the agreement. Remember, they received monies from the Federal Reserve and haven't applied it to the account. This is what all of you have to remember. In all of your contracts with all of the banks, there is something known as the indemnification clause. That means that you did agree, don't say you didn't, you agreed to hold the bank harmless should they cause you injury. Harmless, you said. Well, ladies and gentlemen, you have to notify whomever you're bringing your claim to that you are challenging, especially in small claims court, that you are challenging the hold harmless clause because the hold harmless clause is unconscionable. There is no way in the world you would ever say that the bank could receive the monies from the Federal Reserve under the Federal Reserve Act or violate the terms of the agreement and be indemnified, and then you not be indemnified for violating the terms of the agreement by them trying to hold you in default and they can't be held in default. Unconscionable. Ladies and gentlemen, an unconscionable clause in a contract is unlawful. You can get it voided out. Every single case, that's your argument. Unconscionable clause is unconstitutional. It is a violation of due process to have such a clause, and that clause must be held unconstitutional and invalid. Just that simple. See, the bank says, well, we are held completely indemnified, hold harmless, but you, nah, you ain't got no hold harmless. That's your contract. You wrote it. Why would you ever give them a hold harmless clause and you don't have one yourself? So if they can be penalized, never, then you must also have the same equal protection of law. The contract is the law. The protection has to be equal. Equal protection of law is what that clause violates. The contract is the law between the parties. The contract is the law between the parties. Got to remember that. Most of y'all ain't gonna remember that. Y'all gonna be forgetting. Keep forgetting. We're not in love. Anyway, y'all gonna be forgetting. Y'all not supposed to be forgetting this. It's very important that you remember that the contract is the law. And since the contract is the law, then you must recognize that it's an unconscionable clause for them to be held harmless and for you to be held liable and capable of losing your home. Oh, by the way, in small claims court, you also want to bring up what's called the dual collateralization. According to the Federal Reserve Act, Section 16, paragraphs 2 and 4, your property is not the collateral for the loan. The promissory note, when accompanied with the application packet, Federal Reserve Operating Circular 10, Appendix number 3, that is when it's accompanied by the promissory note, is the collateral. Says it right there in the law, not out of your mouth, in the law. And all you gotta do is say, follow the law. That's all you gotta do is say that. Because I'm required to follow the law, you must follow the law. This is what the law says. Well, it says, no, we're under the Federal Reserve Act. All that other stuff is antecedent or secondary. This is the primary focus. Federal Reserve Act, Section 16, paragraphs 2 and 4. Because I applied for the capacity of a bank, and they recognized me of any Federal Reserve bank. That's it. The fact that they gave you the loan means that they recognize you as one of those any Federal Reserve banks. If they recognized you as one of those any Federal Reserve banks, then they got no leg to stand on. Pay attention. They gave you the loan, recognized you as one of those any Federal Reserve banks. Man, what can they say? You can't be in default because now you're a member bank. Now you become an agent of the Federal Reserve, local Federal Reserve agent. All you gotta do is understand it. They did it. They wrote that junk. It's just a matter for you to understand. Many of you guys are not getting it. Many of you are not understanding it, and thus somewhat of a problem. But pay attention. I think if you go back over this, listen to it, see what your remedies are. We got people who got people in jail. Ladies and gentlemen, judges are putting people in jail. They're ignoring people's rights. They're yelling at people. They're just sentencing people to 100 billion years. Ladies and gentlemen, judges can't do that. There's no law that allows a judge to do that. But what if the person is a threat to society? Then sentence them according to what they're accused of, not according to how you like them, don't like them, their personality. Ladies and gentlemen, I don't agree. I don't agree. You have my word, I don't agree that everybody out there who's violent, who is a predator, who is deviant, I don't agree that they should be out there in public. But fine, you must understand the law that is written, as written, says that those individuals have rights. Those individuals have rights. So if they have rights, left, wrongs, if they have rights, then their rights have to be equal to yours. Other than that, the Constitution doesn't work. Other than that, the laws doesn't work. Sorry, we're going to continue to receive those because what's happening right now is I was in the area where I get a signal from this point on. So, getting back to all of you who think that you're better than other people and that they don't deserve this, but you do, stop smoking that stuff. You're going to cause damage to yourself and probably others around you. Stop smoking that stuff. You are no better than nobody else, so stop thinking you're better than your neighbor. Stop thinking you're better than Tommy, Bobby, Ricky, and Mike. Okay? Stop. It don't work that way. Susan and Jill said that you definitely ain't better than them. Okay? And Ann seconded their emotion. And Diana wants to come and say she wants to start a whole new group. Okay, talking about the subjectors, because she realized they ain't no longer supreme. Ladies and gentlemen, basic instructions, basic instructions, basic instructions. Somebody has to figure out how to put these individuals who think they're in charge in check. The people have always been in charge. The people have always been in charge. It's just the people don't know how to speak up no more. People are blind, deaf, dumb, ignorant, stupid, moronic, because they're people. People are stupid anyway. And because people are what people are, all of you are just going to have to realize that you have more power than you ever knew. Small claims court was created for you. Small claims court was not created for them. So utilize small claims court. Small claims court is equity. Don't believe me? Go back and take a look. And the court is not allowed to ignore equity. Right and wrong, ladies and gentlemen, the one thing that y'all don't realize, and y'all need to pay attention because this is very important, is that when you are in small claims court, that's your court. That's why Judge Wapner's court was called the People's Court. Small claims court was created for you, wasn't created for lawyers. Small claims court, remember, you don't want to go for the value of the property. This is not about the property. This is solely this is solely about violation of the Truth in Lending Act. That's all this is about. Ladies and gentlemen, I am in the cavern to where I live. I am in the cavern to where I live. Okay? Now I has to pull over because we're going to bring this video to its closing so that y'all can, I got about 15 minutes before I get home, or maybe 10. But either way, I'm almost there. Look at that. 41 minutes. That's good enough. Hey, y'all take care. We'll speak in a minute.